Hello. In this segment from our Justia webinar, Practice Law with AI Without Losing Your Law License, we will go through some of the recommendations regarding the ethics and responsibilities behind the usage of AI in legal practice. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Now, moving on from marketing your firm using AI and not just ChatGPT, but all kinds of different AI tools, we're going to look at some of the ethics that tie into this and, where your professional obligations come into play with these AI tools and using them as part of your practice. So Kara, why don't you take that away?
Yeah, thanks. So AI can be a really great tool, as Marina mentioned, but it can bring up some ethics concerns. You need to keep these in mind, but as long as you do, you can take full advantage of everything AI can offer you. We took a look at the rules of professional conduct, and they don't specifically address AI, at least not yet. But Marina and I have identified a few rules we think you should keep in mind. And note that this isn't an exhaustive list, but we hope it's helpful. So the first rule, as you can see, is Rule 1.1, which is your duty of competence. The especially important part of this rule is Comment 8, which was adopted by more than 30 states. Comment 8 says that your duty of competence includes a duty to be current on relevant technology. AI seems to fit squarely within this rule, given how much it's already being used in legal fields. Not only do you need to know that AI exists and is being used by other lawyers and legal professionals, but you need to have a general idea of how it works and what its limits are. AI is often a black box, meaning you can't really know how an AI tool came up with its responses. But this is not really a good excuse for not knowing about what you can do and what you can't do with AI. Like the fact that it can hallucinate and give incorrect or untrue responses can be kind of an issue, or the fact that its data set could be old. As Marina mentioned, AI can also be flawed and biased, even though these limitations might not be immediately apparent. There is such a thing as explainable AI, which strives to provide more of an explanation for answers, but you should still be cautious. In order to comply with Rule 1.1, you should generally know how the AI tool you're using works. You should know what it can accomplish and what it can't accomplish. You also have a duty to supervise other lawyers and non-lawyers, which Marina will talk more about.
All right, picking back up, that pesky mute button really is giving me trouble today. So basically there is a duty to supervise your non-lawyers, right? So you're looking at Rule 5.3 here, and that deals with non-lawyer assistants. It's in the ABA model rules. Many jurisdictions have their corollary to this, right? So at the end of the day, you've got to look at your jurisdiction's version of this, but it's out there for the vast majority of us. And they clarified the ABA in their forward thinkingness that Rule 5.3 applies to non-human assistants. And they actually made this clarification back in 2012. And it deals with non-lawyers employed, retained by, or associated with a lawyer. And with the idea that this applies to non-human assistants as well, then you can say that Rule 5.3 also extends to any AI tools you might be using. And I believe that should be next right here in June 7th of 2023. The ABA issued a formal opinion on this, so we're in the thick of it right now. And formal opinion 506 states that lawyers can train non-lawyer assistants to do things like prospective client intake tasks. But whether or not the non-lawyer can actually answer the questions presented depends on the specific question. And you, as the lawyer, are obligated to ensure that the non-lawyer does not engage in the unauthorized practice of law, that any information provided is accurate. But otherwise, it's okay to have non-lawyer assistance. So when you're using some of these AI tools, you definitely have to treat it much like you would a paralegal or a law clerk or any other sort of non-lawyer that is helping you with your day-to-day practice efforts. So what does that mean for you? That you could potentially use AI for things like getting initial information about a new matter, performing initial conflict checks, determining whether the assistance sought matches your practice area. Is this a good case for you? Or are you a criminal lawyer and this is an estate planning case? The AI can generally answer questions about fees or the representation process, and get signatures on fee agreements. The ABA says, provided that the potential client is given the opportunity to speak to you as the lawyer. Now, how your individual jurisdiction will handle these things remains to be seen, likely for many of you, but it's something to keep in mind that the ABA at least has given some of these examples out here. Now, there are things that a non-lawyer cannot do. They cannot tell clients what legal services they should obtain. They cannot actually negotiate your fees or your expenses. They cannot interpret the engagement agreement. And as you know, even, 20, 30 years ago, working with paralegals and law clerks, there are some things that you simply cannot delegate to a legal assistant. There are some things that you as a lawyer just must do. And to the extent that that is true of a task, you also generally cannot delegate it in its entirety to your AI tool. So you have to balance this obligation, right? The things that cannot be delegated to an AI tool or your paralegal with your duty to be efficient and make those judgment calls about what it is that you as the lawyer have to do, what it is you can seek assistance with doing, AI or elsewhere. And of course, then at the end of the day, the requisite level of caution and oversight that you need to implement to ensure that you're still maintaining the rest of your professional obligation. Excuse me, I am speeding through Kara's next slides. With that in mind, we're going to go ahead and move on to candor towards the tribunal and looking at how that ties into using AI in your practice.
Yeah, so this ties in really well because it's also a reason that you need to be cautious about delegating tasks to AI. So as we know, Rule 3.3 says you can't knowingly make a false statement of law or fact. And in Stephen Schwartz's case, he not only submitted those non-existent cases, but he continued to claim that it never ever crossed his mind that ChatGPT could fabricate them, even when the other side told the court they couldn't find them. So basically what you need to do to comply with Rule 3.3 is to double check the accuracy of anything an AI tool is generating for you and make sure that you're not violating that rule when you are in front of the court. Another rule is Rule 1.6, your duty of confidentiality. You need to make reasonable efforts to prevent inadvertent or unauthorized disclosure of or access to client information. We touched on this before when we were talking about generating client correspondence. You should really be careful about putting sensitive client information into an AI tool like ChatGPT. You should carefully review how the tool uses, stores, and protects information. It's not always apparent how an AI tool is using the data you're giving it access to. If you've used an AI tool before, you might have clicked that little X or the trash can icon to delete a conversation, and it looked like it was gone, but you really can't be sure. Every AI tool will work differently and be subject to different policies. And on top of that, the way the AI tool works and those policies can both change. So you need to make sure that you're staying up to date. One of the things an AI tool might use information you give it for is training. The risk is probably low, but just something to keep in mind. ChatGPT, at least, can be used in sort of an incognito mode, which they say means they won't use new conversations for training and they won't save chat history. So if you're using ChatGPT, you should at least use that layer of protection. You can get to this by clicking the 3 dots next to your name in ChatGPT, going to settings, selecting data controls, and turning off chat history and training. But note that it'll look like ChatGPT isn't saving any of your conversations, but it actually does. It stores them for 30 days before it deletes them. They also have a little disclaimer that they can't prevent unauthorized browser add-ons or malware on your computer from storing your history. So this isn't really a foolproof protection. You probably should not start sharing sensitive information with ChatGPT just because you've toggled this switch, but you should do it anyway so you can take advantage of the extra protections. And you should also make sure that you're continuing to check if ChatGPT has recently updated or changed its policies and practices before you use it. An additional concern here would be the possibility that sharing client information with an AI tool could waive attorney-client privilege. There's no clear guidance on this issue yet, but just something to keep in mind. Another more immediate concern is the possibility of a data breach. ChatGPT at least announced a bug in March that allowed some users to see others' search history and payment information. So you need to take some precautions and do what you can to protect sensitive client information. AI tools created specifically for lawyers might have better practices in place, or at least they'll give you clear information about how the data is being used, stored, and protected. But you should still investigate and decide for yourself whether a specific AI tool is capable of allowing you to fulfill your duties as a lawyer. Now, Marina is going to talk more about a few last ethical concerns.
Thanks, Kara. So something to keep in mind here too is that you have the ultimate responsibility for your work product. So this is something we talked a little bit earlier about non-lawyer assistants, but just to kind of remind you again, that as a lawyer, you are responsible for your work product at the end of the day. And it can't be shoved off and say that you didn't know ChatGPT could lie, or that it would be wrong, that you didn't know your AI tool wasn't working, that you didn't know your law clerk did that you didn't know your paralegal did that. At the end of the day, bars have been very clear for quite some time that the lawyer is ultimately the one that is responsible for these things. So if you as a lawyer would be liable for it, you can't say, well, because your paralegal did it, that it wasn't your problem. And so you need to keep that in mind when you're using these AI tools. Something that ties into that is this idea of plagiarism, right? That we all agree, regardless of our attorney ethics, you've heard this since you were a child, likely in school, plagiarism is bad. You don't want to plagiarize something. You don't want to take somebody else's work product. You can't pass somebody else's work product off as your own. But there is a concern that perhaps AI tools are capable of that. And so it's something to keep in mind. First of all, authorship and copyright issues. Who has that ultimate ownership? ChatGPT would say that you have the right to take the content that's generated from it and use it. And that's awesome, but did it generate that same content for someone else? And could you copyright it? This has come up before in the context of artwork, and I am no copyright expert, but my understanding is that, the US law, as far as copyrights, has consistently been shown to at least apply over and over only when there's a human authorship component. And so if a human is not involved in generating something like your content for your website, then do you really have the ability to claim it? We don't know. We don't know yet. And there's a lot of discussion about this still. There's people arguing both ways. And I am sure we will eventually get an answer, especially as AI tools become more and more, a part of our day-to-day life. But it's just something to be aware of right now. And then, of course, that dovetails into the plagiarism concern, because you've got AI tools out there. They operate on this body of knowledge that was given to it, this corpus from other sources, and they're trained and they take user queries. And then with that, they train themselves and learn new things. And so is it plagiarizing? Did you take someone else's work unknowingly through an AI tool and engage in plagiarism? And so that is an issue that came up. So for instance, on message boards late last year, people started noticing that image AI tools seem to have the Getty Images logo appearing in generated images. So you've got people on message boards before any company has realized this, asking, hey, why is this happening? I'm using this AI tool to generate something new. And then lo and behold, Getty Images starts suing the creators of this AI art tool for scraping its content and then using it to create these new AI generated images that look an awful lot like Getty Images and even include the watermark. And so, that's something there that you have to be aware of. Is it's still a new technology, it's still a developing technology, and those that are geared for the legal industry likely have some sort of safeguards in place for this, but we don't know yet that it's foolproof, and I wouldn't bet on any of it being foolproof. So you need to be aware of the idea about plagiarism maybe being a concern, copyright being a concern, and of course, how those things tie into your ethical obligations. So, with that in mind, your kind of key considerations here are that AI tools can be a great resource for lawyers, right? They can definitely help you streamline your practice, do things more effectively, do things more efficiently, explain on your skills. And there's a world of possibility in how the practice of law can be benefited by this new technology. But of course, if you haven't heard me today, like a broken record that I've been, caution is going to be the name of the game, at least for this foreseeable future, that you have to safeguard your own professional obligations, that you have to be mindful of potential errors and inaccuracies, that you're still going to have to be involved in that process. And ultimately, at the end of the day, accept that you are the one who holds that professional responsibility so you don't find yourself in trouble with a court and you're not the story at the beginning of another webinar like this. Kara, I don't know if you have anything else that you would like to add to these, final conclusions and thoughts for today.
Yeah, no, just underlining caution, 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 but also get in there and try it for yourself. AI is permeating everything in legal space right now, and you're going to be in a disadvantage if you don't learn a little bit more about it.
Sounds great. So with that in mind, we're going to, end this little broadcast here, but Kara and I will be with you guys in just a moment for some live question and answers, and hopefully you guys learned a lot.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.